I have the Honorable Jonathan Odur, a Rute South Member of Parliament in Lira District. Thank you so much for joining us, Honorable. Good evening, sir.
Good evening, and thank you for hosting me.
We have the Director Legal Affairs at the NRM Party, Mr. Enoch Barata. Thank you so much for joining us. Good evening, sir.
Good evening, Patrick, and good evening, viewers. Happy to be here.
And we have a human rights defender, human rights lawyer, Mr. George Musisi. Thank you so much for joining us. Good evening.
Pleasure to be here. Good evening.
Actually, let me begin from the other side, because for sure I know that you have discussed this before, but you're also a lawyer and a human rights defender, and you've had people in the court-martial whom you've been defending. When the Supreme Court pronounces itself about the court-martial, and the government is still trying to push this, trying to amend it, will the amendment make it better so that if you have somebody you have to defend in a court-martial, if it is legal and has been passed and has been amended, you'll have no problem with that, will you?
Of course, there are some aspects of the judgment that advise that indeed there are amendments which need to be made to make those courts a bit more fairer. Notwithstanding given the kind of people being charged, even if it's for soldiers. For instance, issues of the competence of the people who are trying the people. The Chief Justice noted that in the UPDF Act, there are punishments which attract a death penalty, many of them. And you find that they can be tried by a person who doesn't even have any form of legal knowledge. So even if you're a soldier, that's meant to protect you. Issues of the independence of those courts, because it was also one of those things in question. In fact, one of the judges noted that maybe these people need to be brought under the purview of the judiciary, under some sort of, like a division, like we see divisions of the High Court. Because as it were, a chairman court-martial could be sacked at any time. And the commander-in-chief had the powers to appoint anyone, even you, Patrick Kamara, and you'd start administering cases the following day. So to create some bit of independence for those courts. So those were proposals which the CJ Code advisory for purposes of amending the law, and it was well intentioned, and the following days we saw the Attorney General withdrawing the bill which was in Parliament for purpose of possibly bringing comprehensive issues. However, there's another very sticky issue, which is the trial of civilians in court-martials, and we know that the reason why Honorable Kabazuguruka went to court in the first place, that was the biggest issue he was trying. When he appeared before the court-martial under General Guti, he said that I'm not supposed to be here, I'm a civilian and I'm supposed to be before another court. So the bigger spirit of Kabazuguruka, the two cases, and the judgment of the Constitutional Court, which was upheld by the Supreme Court, was that civilians should not be tried in the court-martial. Now, what we are seeing from government, like, of course, we've not got the benefit of seeing any draft bill presented, but from the resolutions of the caucus that were shared and what the minister shared yesterday, we see that they are clothing the good-intentioned adjustments or amendments that court recommended together with this poisonous chalice that the general public is worried about, the issue of trial of civilians.
So you're saying if it is amended, it should be amended, but only to serve the serving soldiers, right?
Yes, serving soldiers, and of course even the issue of the right of appeal, even for serving soldiers. It was also one of those issues that it doesn't matter, because as it is now, there was no direct right of appeal from the military courts to the civil courts. That even if it's a soldier who is dissatisfied with the highest court in the military, he or she should be given a chance to appeal the decision to these civil courts for either confirmation or reversal.
Mr. Enoch Barata, you're Director of Legal Affairs at the NRM Party, and people are wondering, why would you want civilians tried in a military court, and yet there are civilian courts that can competently handle any case involving civilians, that the military court should be handling issues for offenses committed in service or in the line of their duty as soldiers?
Thank you, Patrick. I think the beginning point is to, first of all, have a proper understanding of what it is that the Supreme Court decided. And you have to understand it without bias. The first and main thing is that the Supreme Court did determine that the existence of the General Court-Martial and it's being in place is constitutional. Its establishment under the UPDF Act is constitutional. However, the Supreme Court did find that in its present setup, at the time, it did not offer certain guarantees of a fair hearing for mainly a few reasons, one of which was the qualification of the officers presiding over the cases, the nature of their independence, the tenure of their office, and then it also came to the right of appeal, especially considering their determination of capital offenses. So essentially what the Supreme Court said is, while this is a proper court established within the law and under the Constitution, you must put in place the rest of the mechanisms in order to continue. Now, regarding the trial of civilians, the main thrust really was, do not duplicate judicial authority. Do not duplicate it. And if you are going to try, and that is in the judgment, by the way, if you are going to try a civilian in the court martial, you must be able to demonstrate that there is exceptional circumstance that requires that trial of the civilian in the military court, and that you must demonstrate that that case would not be properly tried in a civilian court.
So if you can hold there, if you can
it is
hold
an
there,
exceptional. It is an exceptional.
If you can hold there, so there's a belief, and that there's that exception, and the time can come when the civilian court cannot try civilians.
Certainly.
In what like what?
Let me give you an example. You are a media professional, you are a journalist. I don't know if I can describe you that way, but let's assume that you are. That is how, I don't know. I know there are different media people, but let's assume that you are a journalist and you accompany soldiers in an operation. You are permitted to accompany soldiers in an operation.
We have done embedded reporting.
Exactly. But then when you reach the operational area, you begin transmitting and disseminating confidential information about locations of the people and so on, and therefore attract the enemy force to attack. Now, if you're going to be tried by, for example, the unit in the area, the court martial for that unit, we don't have, the military doesn't have time in the middle of an operation to bring you back. First of all, you have embedded yourself in a live and active military operation.
By the way, you cannot embed yourself. To be to do embedded journalism, you have to be accepted and invited by the military that you are going to go with. And I have done this a couple of times in the Congo and in Sudan.
Absolutely, without a doubt, without a doubt. And that comes with an obligation. It is not the same thing as walking on the Kampala Road and creating a story. That is a special operation, and that is why you are there, and you must respect certain rules. So if something happens there, then it is unlikely, it is complicated for the soldiers to say, let's leave this and first go back. That's a different thing now. So there are some of those things that are exceptional. But as I said, the exception has to be established. The exception has to be very clear from the beginning. And the challenge with the previous law, according to the Supreme Court, was that it was very generalized. For example, the definition of what a service offense meant, they said any offense under this act and any other law. So that was a very generalized definition. So I think the idea would be to now be more specific, that you eliminate those other things and you delineate very clearly what are those exceptional circumstances, which must be truly exceptional, for you to be tried in a court martial. So,
Honorable Jonathan Odur, do you also subscribe to the idea that a civilian can commit an offense, and that offense is so exceptional that civilian courts cannot be able to handle?
Actually, I do not. And my understanding is that there was a question before the Constitutional Court, and the question was whether a civilian can be tried in the court-martial. And the answer was that a civilian cannot be tried in the court-martial. The Attorney General appealed and went to the Supreme Court, and that was the same question. And I think in an attempt to explain their answer of why a civilian should not be tried, the Supreme Court went into some subsets of questions to help them analyze and come to that conclusion. In doing that, they touched so many issues, but in the end, their answer was it is unconstitutional to try a civilian in the court-martial. I stand, and I think firmly as such, to say that I do not support, and I think any other proposal to try to dress that wound, to cover that wound, to provide for a civilian to be tried before the court-martial will not meet the constitutional test. I should also add that the judges do not make laws. While they advised and touched in, I looked at all their judgments. I think the main ones we are relying on, and I think the NRM caucus relied on, they picked from some of the analysis made by one or two justices of the Supreme Court. That cannot be the collective decision of the Supreme Court. Their decision was reduced in writing, and we all know, and there is nowhere where they say to go and amend the law to allow trial of civilians before the court-martial. My other understanding is, when you look at the police, they have the police professional standards unit, which in itself you can clothe this as a court to deal with service offenses within the meaning and service of the police. If you go to the Prisons Act, they also have a disciplinary unit, I don't know the exact name, to deal with service offenses of the Uganda Prison Service. In the UPDF Act as well, there were these offenses that were envisaged that in the execution of duties, lawful duties, in the execution of your service, you are likely to have some breaches that are not necessarily criminal, but they are administrative, they are disciplinary issues that we need to sort it out. And I will give you an example. If you are a soldier and you are given fuel to deliver some ammunitions, and you reach somewhere on the way, you start selling that fuel, and then you also start maybe selling the ammunition. You may not be brought to the civilian courts. That is an administrative thing. You may get your punishment there. Or we have deployed you to go and fight Joseph Kony. You reach on the way because of fear or any other reason, you desert. You leave the force.
Cowardice in action. Yes,
that is a service offense, and we need to try you and either dismiss you or give you the punishment. That was the spirit of providing a mechanism within the army to deal with its cases of indiscipline.
Mr. Barata, when you hear Honorable Jonathan Odur make that kind of submission, which I'm inclined to believe that this was intended to look into service offenses, more or less like a disciplinary committee of the army when somebody has derailed off from the line, to bring them to the line or maybe punish them. The idea of bringing in civilians is far-fetched.
So, first of all, I agree with Honorable Odur when he states, and I think very correctly, that courts do not legislate. The legislative function lies with Parliament. If you read Article 129 of the Constitution that lists the courts of judicature and also makes provision for subordinate courts, it establishes those courts, but it does not establish, it does not define the jurisdiction, particularly of each of those courts. It leaves that function to Parliament. So Parliament vests the several judicial bodies, even the quasi-judicial bodies like tribunals that we know we have several tribunals, the PPDA tribunal, the tax appeals tribunal, etc., etc. It is an act of parliament that vests those with a jurisdiction. The jurisdiction of the court-martial was challenged to the extent that it did not conform, the exercise of that jurisdiction and the manner in which it was stated did not conform with certain constitutional provisions. In other words, if you streamlined that and brought it into conformity with the constitutional provisions, then you would operate correctly. Now, the second area is I disagree, I mean I agree in part with Honorable Duru, but I think something needs to be understood. The comparison with the General Court Martial and the Courts Martial are not comparable to, for example, the disciplinary committee of police or prisons. There were two other structures within the UPDF, the STA, the Summary Trial Authority, and the UDC, the Unit Disciplinary Committee. Now, those were also declared unconstitutional because those were purely disciplinary structures, but which were found to be trying more offenses outside discipline. Those can be compared to the police, but the General Court Martial was properly declared as a subordinate court, constitutionally established under the relevant section, I think 197 of the UPDF Act, and under Article 129(1)(d), probably, of the Constitution. So that must be understood. So I think what Cabinet is now dealing with is to streamline the structure and operations of the courts martial to bring them in conformity with the constitutional provisions. And the main things that the Supreme Court highlighted were, number one, the nature of appointment, which leads to the questions about the independence. Number two was the qualifications of the people presiding over. Number three was the tenure of office. Number five was, is there an appeal process that allows for you to appeal out of the court martial through the other courts, because there are certain provisions. For example, a death penalty for life imprisonment. Those must constitutionally go to the Supreme Court.
All those issues you're highlighting,
yes,
we can agree they needed to be done. But the elephant in the room is trying civilians in the court.
And that too, by the way,
even the soldiers, even the serving soldiers also need somebody with a legal background.
I agree.
They need all those structures so that they can deal with their matters.
100%.
But to bring Enoch before a court martial,
agree.
The Supreme Court want to defend you, not to appear in that general court martial.
I agree that those need to be attended to. What I also disagree with my land friend Honorable Dur, he says they picked some things from here and here in the opinions. No, these were declarations. These were the final declarations read out after everybody had read their judgment. The Chief Justice reads out the declarations of court and also reads what they call the advisory opinions. Right. The advisory opinions are simply advisory opinions, and they can be adjusted somehow.
Jonathan, Enoch, and George, gentlemen, hold on to your points because we're going to take a break. On the spot, we'll be right back. Welcome back. You're watching On the Spot. My name is Patrick Amar. My guest tonight, I have Mr. George Musisi, a human rights lawyer, Honorable Jonathan Odur, a Rute South Member of Parliament in Lira District, and we have the Director of Legal Affairs at the NRM Party, Mr. Enoch Barata. We're discussing government's final push for UPDF Amendment Bill. You know, George, you know what is intriguing is that we have a Ugandan facing serious charges of terrorism, of kidnap, of murder, of rape, you know, crimes against humanity, trans-border crimes. I'm talking about the alleged command of the ADF, Jamil Mukulu. He's being handled by a civilian court. And the government and everybody thinks the civilian courts are handling. And I don't think there's anybody, other civilians who are facing such serious charges than Jamil Mukulu. But the civilian courts are handling. What do you think is pushing government to think the likes of us can actually go to the general court martial, but Mukulu, Jamil, who is facing serious charges, is in a civilian court?
The push is mired in politics, period. There has never been a time before than the army courts were so weaponized as a political tool than the last 2021 general elections. Over 600 youths were arraigned before the different court martials. On one day, I remember myself and the Honorable Shami Malende, we bailed out 300 youths from Bombo Division Court Martial. So the push is just politics. And of all those people who are being charged, none of them was being charged with being found with a weapon. Right now, when they're making the justification for this, they're saying, no, there are some civilians who are found with very serious weapons. First of all, we all know here, and I'm sure even Mr. Barata would agree, that our courts, for instance, the High Court, has unlimited jurisdiction to try any offense under the sun. For crying out loud, people who were convicted of bombing people in Uganda were tried by civil courts in 2010. They are tried and convicted by the... So you are saying that these civilian courts can try terrorists who have killed Ugandans, who have planned transborder crimes, but they cannot try someone found with a t-shirt, a red t-shirt. So the furor of the public regarding army courts is largely because they have been brought to the forefront of the politics. And the reason why the people are against this, even before they bring the draft, because they know that as we head towards elections, it's being weaponized again. I can also tell you that in many of those cases, they wouldn't be taken through a trial and a conviction. They would all be remanded without trials until the people get tired. Leave alone these Olivia Hotels. There was another group, a bigger group. So it's mired, the push is mired in the politics, and you cannot separate it from the politics because of the context we are having now, that army courts have, it's not about what they are talking about, that there are any technical people. In any case, you are saying that a judge of the High Court cannot try someone allegedly found with a bullet. And then you are presenting them before a person of unknown qualifications for trial.
But even if the legal issue, I mean, the background of the legal expertise is brought into the general court martial, at the end of the day, if somebody wants to seek redress, he will still appeal in the civilian courts. That's what they want to do, isn't it?
Of course, the question is, let us look at how the courts have been used. I represent clients like rightly introduced. You remember at the time, they were arrested in 2010, 2020, 2021. And some of them pleaded guilty and were convicted sometime in, I think, October last year. And others said, no, we don't have any crime. We've not. Until 31st January, when these courts were quashed, they had never been, the group of 9 had never been, the trial had not taken off. So the question is not so much about, Patrick, many of these arrests and arraignment in court are not meant to get a conviction. So you need to see the light of day to get a conviction for purposes of appealing the decision, but for remanding you and until you possibly get done. So it's not that these people will be tried, taken through. The intention of the arrest is not to go through a successful prosecution and conviction. So you don't see the light of day of appealing to the civilian courts.
And George there is a human rights defender. He's been defending many people who have found themselves in the court martial, giving examples of people who are, just because they put on a t-shirt maybe of loop or a beret, and yet you have hardcore, suspected hardcore criminals facing suspected hardcore charges, and the court martial are handling. You are an officer of court, really. Now, do you speak about this with a lot of confidence and conviction?
We run the danger of trivializing a very serious matter and a very serious discussion. If we reduce it to a t-shirt and a bullet, that is a misrepresentation.
No, he just picked it as an example.
My land friend,
Mr. Barata, he only picked it as an example.
I will tell you, Patrick, my land friend is a lawyer of good standing. unfortunately, he's also a politician.
No, but it's a statement of fact.
So there is a tendency, and I'm only, these are statements of fact.
You're a politician
there's
too.
No harm. No, I am not a politician. But the tendency is to view everything in a political light, which I would like to move away from a moment. But let me first answer one of your questions by posing.
So your submission is purely legal, right?
Purely legal. Let me pose to you a question, and my land friends are invited to answer. You asked, why is Jamiru Mukuru being tried in the International War Crimes Division of the court? And I will ask you, why was Thomas Kuoyelo tried in The Hague? Did we not have courts here to try Thomas Kuoyelo? There is a setup for everything. There is a system set up for everything, and there are special considerations. Jamiru Mukuru is being tried on international crimes. If there are charges that are related to military, maybe those have not yet come, but for now, he's being charged for international crimes. And we must respect certain systems. That is, we cannot compare these things, and up and appear are different things. So there is a system. And I don't want us to discuss this matter as if nothing is being done, or as if we are still in a pre-judgment situation. We were in a pre-judgment situation. The judgment came. The judgment was accepted and is being implemented. And one of the things that towards implementing that judgment and the decisions of the Supreme Court is amending the law. That is why the bill was already in Parliament. There was already a bill to amend the UPDF Act, by the way, which had already removed several things, like the field court martial was already removed. These UDCs and these STAs were already going to be removed. So it was withdrawn to say, let's make now comprehensive, because certain other things have come up. Let's make a comprehensive, which makes absolute sense. So let's not discuss this and confuse the public as if we are still back there. No, we are saying there was a problem identified. Can the problem be addressed? Are there credible efforts to address that problem? And I think there are.
Honorable Jonathan Odur, what do you make of his submission?
You see, I do not think that there is any need for an amendment to take care of the pronouncements of court. First of all, in the exercise of his powers as the commander-in-chief in appointing the panel that sits on the court-martial, there is no restriction. Nobody has stopped the commander-in-chief from appointing a soldier who is a legal expert. We have a number of them. I can mention others have retired, who are advocates of the High Court of long-standing. They attend all the law society, you know, CLE and all this. They are there, and they are still serving. We have them. Nothing stops the president, even without any express provision of the law, of appointing a soldier who is qualified to be a judge of the High Court or the judicial officer to that. Secondly, nothing stops the president from appointing a qualified prosecutor who is also a soldier and with all the qualifications, and it is the executive to skill the prosecutors to equip them and skill them to prosecute all these cases. So to justify the withdrawal of the amendment, which amendment was very good, I must say the original version of the amendment as was presented to Parliament, if I recall, wanted to deal with about 5 issues. The first one was to restructure the organs and structure of the UPDF to match the current standing, which is good. There are some changes that have been made. The second one was to establish what they call a health service award, some kind of health scheme to address the health challenges that the soldiers go through, the access to good medical treatment. The third area, if I recall correctly, was to deal with management of pensions, gratuity, compensation in case a soldier gets incapacitated during service. And the last area, I think, was to establish a medical board. Very good, about 97 clauses that had come. Within those 97 clauses, there was a clause to deal with to deal with sections 194A, B, and C, which was introducing a service disciplinary unit. And I like the choice of the word in that amendment, that they were introducing a service disciplinary unit. I still insist that you must be in the service of the UPDF, and you must be exercising lawful orders within the service for you to be tried. If you are a soldier, you are just a soldier, and you commit an offense, a penal offense, but you are not deployed, you should be tried in the civilian court. Yeah. But if in the course of your duty, service offense. Yes. Now, how do you bring me, Jonathan, who probably we have committed an offense with a soldier, but I am not in your service? There is no commander that had given me a deployment as a civilian that go and do this. So how do you admit me into the UPDF? And there's a clear criteria for anyone to become a soldier. We know adverts are run, you must train, you must meet the medical test. Now you want to give me an army number, and yet when I go for admission, you say if you don't have one, if you don't have a tooth, we cannot admit you. If you have an STD, we cannot allow you to join the army. But now you are conscripting me for the purpose of just trying me. Now, my question, the big concern that I have is, in the analysis, I think, of the Chief Justice, he seemed to suggest that it is possible to deal with those offenses involving soldiers at the level of the High Court, but if there is need for a specialized court, then the system can create what they call a division. Now, the senior lawyers are here. I don't know how the commercial court was created. I don't know how the...
Okay, but you know, there is something, Honorable Dur, there's something you mentioned, and you talked about 97 clauses to change?
Yes.
Yeah, but I'm like, really? Okay, 97, couldn't they just come up with a new legislation completely? Because how do you start?
It is a new legislation, Patrick.
Because you're doing an amendment.
Oh yes, it is called, it's an amendment bill, because there is an amendment. Once there is an act, any change to it just becomes an amendment.
No, you have a point.
I think his point is that why don't you repeal the entire law?
No, exactly. Yeah. No, you repeal the law in certain circumstances. If you are going to combine it, for example, with the Police Act or the Prisons Act, then you do combine them and then repeal one of them. But there is no harm. That is really...
Well, it's for you, the lawyers, to consider.
There is no harm. There is no harm.
This is too many things to change, as if you're doing a total overhaul of them.
No,
that is a work that Parliament is paid to do, yes. to receive proposals from the executive, either agree with it, vary some, or even reject. But the main issue I am emphasizing is that there is no need to withdraw that bill to go and provide for things that can be done by a statutory instrument. For example, I understood that it was just a matter of talking to the judiciary at that level, and maybe we establish a division of the High Court. I don't know whether they're going to call it a service division or an armed forces division or something like that, presided over by justices, whom, by the way, the president has the benefit of appointing them, and he has been appointing all these judicial officers. And we can say that if you look at the example he gave, the complex cases of the Chadondo bombings, a number of other cases that would ordinarily, in the present circumstance, be before the court martial, has been disposed of very well by the courts of judicature. So I still insist, and I don't know whether my senior brother, being the legal director, had the opportunity to advise, because I thought the president panicked a lot when that judgment came from the Supreme Court. The tone in his written letter, and I could see the advice he received. He quoted the Attorney General. I don't know whether it was an opinion on phone, but I felt that at the level of the presidency, with the benefit of having access to competent lawyers spread across government, it was not necessary for the president to panic and to appear to be angry and to try to rush that process. But I'm happy that after moving in a very high speed, they seem to realize that it's no longer as easy as they thought, and I'm still hopeful that the legal brains within the system will be honest with them. That's what I was taught at law school, that as a lawyer you have to be honest, whether the person seeking advice from you will agree with you or not. So I hope the seniors will be able to advise that this is not the correct way to deal with this matter, and maybe that amendment will be dropped. I still hope so.
Enoch, as a lawyer yourself, don't you think this processing of this bill contravenes Article 92 of the Ugandan Constitution, which prohibits Parliament from passing a law which contradicts court ruling on a specific matter?
Okay. Now, first of all, let me just briefly state that the methods that are chosen to address a problem can be varied as long as they address a problem. So I think it is a bit too presumptuous to suggest that the president should use this method and not the other, while both of them are available to you. What the Supreme Court said is we need to see actual guarantees that the courts martial can deliver free and fair justice to the people that appear before it. Now, that is why it is necessary.
Was the Supreme Court also very clear that as it does that of delivering justice, yes, that includes civilians?
No, there was a different there were different pronouncements, by the way, on civilians. There were different pronouncements on civilians, and the civilians, the general rule, the general statement.
Is it your understanding, Enoch, that the court spoke with clarity that if you make these amendments, yes, civilians can be tried in the court-martial?
Yes,
is that what
the court said?
Is that your submission?
If you can prove specific and very exceptional circumstances, and you would have to convince court at the beginning that there are serious exceptional circumstances, then you might be able to make a provision if it conforms to the constitutional provisions. Now, coming to Section 92, when you Section 92 is also thrown around that, but there is nothing here that is going to defeat the judgment of court. Court said you do not have qualified people. If I put a qualified person, have I breached Article 92? Article 92, by the way, is the one that says that you do not create a law to defeat a judgment of court. Yeah. So the court has said you did not have qualified people. I am making a law to say I am specifying qualifications of people in accordance with what the court said. Have I defeated it? No. Court is saying the manner of appointment of this does not guarantee independence. From what I read, from what came from cabinet, at least as far as was reported, is they are saying we will first of all have these people qualified. Two, we will have the involvement of the Judicial Service Commission in appointing them. Have I defeated the judgment of court, or have I enforced the judgment of court? So these are areas that I think people need to clarify and stop being perfunctory about and emotional. These are very serious national issues, and I think we do them a disservice if we only view them in a political lens and say, oh, these courts anyway, they are used for politics and so on and so forth. I think it's a bit wider than that, and we need to think about wider issues, and we need to think ahead beyond, we need to think about the security of this country beyond a simple run around
George,
politics.
Yeah, okay, George, is it also your understanding that the Supreme Court's ruling meant that if you made some changes or amendments, then yes, civilians can also be tried in the military court, like Enoch is reading it?
No. Of course, Enoch has accused me and Jonathan of interpreting the law politically, and it's surprising that Enoch who is the chief legal advisor of a political party, thinks politicians. He says no.
Yes,
law is made.
Yes, I advise
political
I advise them, and
law
I know
is
that
made by politicians.
To be unreasonable.
But with all respect, Enoch, you seem to be more political than the other colleagues of yours.
No. I am strictly telling you what the law is.
Enoch should know that law is made by politicians. Law arises from politics of the day, and even this particular issue, the uproar of the public, and of course it's not even looking at it in narrow sense. Actually, I would accuse Enoch of glossing over very serious issues, because to have someone being found with a t-shirt and charge them with treachery, an offense which attracts a capital death sentence, it's actually you who is glossing over very serious issues. It's someone's life at stake. The uproar that the general public has had over has not been because the general court martial has been trying maybe armed robbers. No one has complained about armed robbers being arraigned. Back to your question, Patrick, and Honorable Jonathan had earlier talked about it, that the main grievance of Honorable Kabaziguruka, the main petition in that matter, was the issue of civilian trials. And that's what the Attorney General was aggrieved about to make the appeal. In fact, these other issues, the advisory opinions, which indeed, and I agree that indeed government can make some amendments which are in line with the judgment. However, the bigger spirit that overrode the judgment, both at the Supreme Court and the Constitutional Court, was the issue of whether civilians should be tried. And there is nowhere in that judgment which said that if you make these changes as per advisory opinions, then it would be okay to try civilians. It doesn't.
I tried to put that question exactly.
Yes.
And
there's no way.
I insist it does. I insist it does. And I wish I had carried my judgment.
Gentlemen,
but
hold on to your
points.
Hold on to your points, because we're going to take a break, and on the spot we'll be right back. Welcome back. You're watching On the Spot. My name is Patrick Amara, and my guests tonight, I have Mr. George Musisi, I have Honorable Jonathan Odur, and Mr. Enoch Barata. You know, Honorable Jonathan Odur, if it makes a comeback to Parliament, this bill, and considering that you don't have the numbers, I'm assuming you're going to be on the opposition side, you don't have the numbers, I mean, it's a game changer. The NRM will come and carry the day. What would be your plan? Do you think you have you can be persuasive enough for your colleagues to consider?
Yes, I think so. And let me use two examples that I am aware of. In that entire judgment, one of the questions was whether the principle of separation of powers, that our democracy is constituted by the legislative arm, the executive, and the judiciary. In the interpretation of court, the Army Court Martial is part and parcel of the executive. And usually complaints arise out of the excesses of the executive. They're the ones who are doing all the things, accusation. So can they sit and adjudicate in a matter where they are the complainant and they are the ones prosecuting? I think that's why court said, no, it cannot. You cannot bring your case, bring the evidence, constitute yourself, hear it, prosecute it, and pass the judgment. And that's why they said, if somebody needs to appear, it must be before an impartial, which is a principle of natural justice, an impartial tribunal. How do we get to that impartiality? It must be a tribunal that does not report to the same executive headed by the president. The second example I want to give you, which is in a record in this country, I cannot recall. I think one of the army generals, maybe the late General Kazini, I think was tried, and a decision was reached, I think, to pass a death sentence on him. Before they did that, the record shows that they had to go to the president, who is the commander-in-chief, and the high command sat and said, do we continue with or not? The second example, there is also a high-ranking officer, it's written all over, I cannot recall, who had committed some offense, tried in the I think General Salim Saleh at some point, if I recall. It was written. General Salim Saleh was accused of doing something, and the court said they wanted to pass, and now they needed the president to bless it. Is that the impartiality that we are talking about? Do you think that the president who has accused, who is the chief accuser in a case, the soldiers who sit, he appoints them, and then when they're about to make a decision as with such a consequence, they come back to him? I think that's why court said no. And I still stand by my interpretation that under no circumstance must civilians be tried by an impartial unit of the executive, part and parcel of the executive. Now, coming to Parliament, I trust in the judgment of the members of Parliament. It's a presumption. Once you are elected a member of Parliament, there are standards that you are expected to live up to. And when facts are as clear as in this case, I don't expect the police to succumb to any manipulation, to succumb to any threat, to succumb to any inducement to be able to pass this law. Because, as we know, the law, once passed, will not be only for some people. It can catch up with you. And let me tell you, we are going into an election.
He's telling them not to succumb to any inducement.
Yeah, I will come to that.
Are there attempts to give you some inducement?
No, what I want Ugandans to know, and also people who are in NRM, is that we are going for an election in 2026. There is no guarantee that this particular candidate and their party will win. It could be UPC. So don't pass that law because you think you are part and parcel of the current government and you'll continue to enjoy that selective application of the law. It's not. Another party may come in. Do we want to use that? Of course, if we take, we will not agree with that kind of approach. So I will be persuading our members of Parliament to think that way. And we have examples that we have in this country already that certain laws were passed, proposed, cheered, and supported by some people, and days after the law came into force, they were the first victims. We do not want to see that with the court martial. And I have been trying to get the interpretation. When you narrow that definition of martial, everywhere I've looked, so many dictionaries, martial restricts to issues of war and aspects of being a soldier. So the moment you put there the word martial, you have already restricted the application. We don't want to go to court and waste the time of court again if that law is passed, because I know court will come to the same conclusion. And like we pointed out earlier, it is not the decision of the Supreme Court. The Court of Appeal, 4-1, I think, had already answered that question. In fact, the extra advices and the extra what by was not even a matter before them. I think they just volunteered. The question before them was, should civilians be tried or not? And the moment they said no, the others were, like he rightly observed, advisory, which may come to Parliament and will reject. So I think members of Parliament are alive to this fact, and I still hope that legal brains around the country that the president has access to, now that things have cooled down, because I believe the president acted really in panic. Okay. But now the facts are clear, he may be able to calm down, and we may not even see that kind of push for that amendment. It's not necessary, really. Enoch,
it appears in Uganda the rule of law is actually being threatened. And the separation of power is also actually being threatened. Why I'm saying this? Because I think there was a time when the Parliament asked the Chief of Defense Forces to appear before a committee of Parliament to answer some questions, and he actually said, I will not, and if anything, I could even arrest you. I mean,
are you going to mention how he referred to them?
I don't remember that.
Called them clowns.
You see, so what do you make of that?
First of all, I would like to first respond to my brother, Honorable Dur. I think there is a bit of pivoting that I see. You are now pivoting from saying, okay, let's leave the Constitution, the Supreme Court ruling, let's go back to the Court of Appeal ruling. I think that kind of pivoting is exactly what defeats the rule of law. And I think we must be honest with ourselves. We must not start ducking things here and there. Now, the CDF did appear in Parliament, and I don't recall. You said he said he will not appear or something like that.
I remember
that I do not recall, because I also are you referring to the tweets? Because I also recall that he said if you take his tweets seriously, then you are also not serious. I don't know if you saw that tweet, but I know that the CDF did appear before Parliament.
Actually, he did not.
Where? I think you mean a certain person did not appear, but I think the CDF did appear.
No, there's a CDF and there's a deputy. There are two offices. You are pivoting.
That is why there is always a deputy.
Yeah.
That is why there is always a deputy.
Yeah.
That is the function of the deputy, that if one is indisposed, the other goes. So I don't think too much should be made of that. But that is I guess that entertains our politicians somehow. So for me, as far as I'm concerned, the government, if what has been reported is correct, and I have no reason to believe that it isn't, is making steps to address the gaps that were identified in the setup and the manner of operation of the courts martial, then the government is on the right track. To try and, I think also to try and see the definition of martial in terms of only war, as my brother says, I think that is quite, you will read, if you read that judgment, you will see there was quite an expose on courts martial world over, and the conclusions are pretty much the same. It's a question of aligning to the best practice.
So I'm sure you, as a human rights lawyer or human rights defender, this is getting you worried that if it's now passed and the civilians can actually be charged in...
By the way, Patrick, I forgot to mention one thing. You know, when you are, my land friend again was talking about the executive appointing. We have so many of those courts. We have tribunals dispensing justice, big justice, and they are directly under ministries, but they are dispensing serious justice. So I think we have to contextualize very many of these things.
So what is the fate? I'm sure of some people you were defending before the and in the now that the Supreme Court pronounced itself, were they released? Some of those who were charged by the court martial and then convicted may be locked up.
I think the only person, to my knowledge, and I think I'm accurate, who has been released since that judgment, who was affected directly, is my brother Aaron Kiza, who was released just almost 1 week ago. And in the ruling of Justice Selubu, he referred to the situation that many of those people are having as some sort of a legal limbo. You know that there were orders that the files be transferred to the civilian courts, all files were, which were ongoing and involved civilians. And I know that the Minister of Justice has stood in the floor of Parliament and has said that all those files have since been transferred, but we don't have any inclination as to when indeed these people will be charged, if at all they are to be charged, because DPP has a discretion not to charge them anyway. But what is the fate? So it's some sort of...
So you have quite a number of people in jail now, and they don't know their fate?
Of course, so many of them. Chitali alone has about 700 people who are on remand from the court martial. And there are many in other facilities. I have people have been representing. We've since applied for bail, which is yet to be had from the civil courts. But of course, the people I'm representing don't even make up 1%. The bigger crisis is for the so many others who have to wait indefinitely because there's no time frame in sight within which I remember on the floor of Parliament, the Attorney General was trying to be put to task. And to use the words of Mr. Barata, he pivoted around the issue by not giving some bit of time frame. So what it means that people are in prison for an unknown period. They can't apply for, they're not under any charge by any court because the other one was frozen. They have not been arraigned before any other court to face another charge. And of course, it's one of the crises of our times.
I've read through this proposed bill, and well, I'm not a legislator like you, but all of you here are lawyers, and I hope I'm not going to be slaughtered on this legal altar. But when it comes, do you think, with all respect, Honorable Jonathan Odur, members of Parliament, your colleagues will have enough time to internalize all these clauses and go through them? It looks very technical, and make a good case about these issues, because sometimes the time that is given, this looks to be very, very technical.
No, they're actually not. In our rules, we have 45 days, and those 45 days are not fixed. The time can be extended. Now, how Parliament works is that we have experts, technical officers available, but the most important aspect of processing a bill is that it's a consultative process. So once we receive these bills, we are supposed to invite different stakeholders, the public, and different organizations who are interested to come and give us their views, which views are supposed to inform the report of the committee and how we take a decision on a clause by clause. So even when a particular member of Parliament is not clothed with enough capacity to understand, but from the public hearings, you are able to form an opinion. We will have different people coming and say, no, we reject, please reject this clause, and these are the reasons, accept this one, including even soldiers, the UPDF. I can tell you that the bill that was withdrawn, we had already started receiving or advice. We have been receiving opinions of retired UPDF officers who are saying, I am interested in this particular clause. I would like you to support it, but make these improvements if they are possible. This aspect has been left out. We would like you to propose. So I think that should not worry Ugandans. What we request, and I hope that the Speaker of Parliament or the Deputy Speaker, whoever will be in charge, will have the patience. The chairman of the committee will have the patience and will reach out, so that in the end, when we make the law is not only the one made by members of Parliament, but also reflects the aspirations, the wishes of all Ugandans. So that process will take place, and I hope we will come to a conclusion that represents the views we have collected.
Somehow you were hinting on that sometimes they can have some inducements to make it easy for the executive to carry the day.
Yeah,
would you mind elaborating on that? It
is not new. Ordinarily, members of Parliament are elected to go and legislate. So we are ready to receive any bill proposed by the executive or by a private member. But there are instances where we have received unpopular bills proposed by the executive, and members are hesitant to pass it. And the executive has been forced to use other unlawful means, sometimes coercion, intimidation, monetary inducements, and we have seen this in this particular Parliament. When the RAPEX bills, the rationalization was taking place, members were opposed to rationalization, especially I can recall Kofi, UNRA, National Forest Authority, the Road Fund, about 6 or 7. And what happened is that a caucus of the NRM took place, and there were promises, said, please go and pass it, we'll get something for you. And members did that, and it's out in the open, and they have been asking, where is that promise? And I must give credit, I think, to the president, that whenever he promises his members of NRM, he delays, but he always makes good of it. And recently, he has just made good. If he was a customer in the bank, he would have very high credit reference bureau rating as somebody who meets his obligation.
Makes good of his promise.
Makes good of his promise.
But talking about, there are allegations, there are all this kind, the pulse of the nation is that there has been 100 million given to members of Parliament, what are their big, so that they can maybe dance to the tune. I am yet to see somebody. Normally when something like this happens, we always see 1 or 2 people come out maybe with a bag of money and say, I'm not touching this evil money. But this time around, allegations are wild everywhere, but no one has come out to say, you know what, I'm not taking this evil money. So, did you get your 100 million?
Let me inform you and the rest that it is true that members of parliament are receiving the 100 million in cash and secrecy in courts. It's not like it's the secret is they're hidden under the water or something like that. From Monday night, several of our colleagues, we are peers, and people check with each other, have you picked yours? I've been called, I'm going to pick, and their confirmations, I've already picked mine. Others are encouraging the rest, please, you go and pick, there's no problem with that. But I can speak for myself that I have not, I don't intend to, and I have not been called, because the money is being, the payment is being made upon calls. In the night you are invited and you come, you are given the money, and you have not received that call. First, because they know what I stand for. It's not the first time. I've been in the 10th Parliament. I've also been in this Parliament. I am on record. I've gone to court and challenged some of those. So that's why they have moved away from payment through the banks, which you have seen us in the past come out boldly and say this amount we were paid, this is the evidence, and this is how we have reversed it. It is now into that kind of secret payment. So when people can stand and say we are not aware about it, it is not happening.
You have actually called it secret payment, but again you want to confirm it has happened. So
no, the secrecy has a,
how do you know the secret? How do you know the secret?
The secrecy is in this context. When the 29 million was paid to MPs for the age limit, it was paid through the bank into our accounts. So you could trace it and you could confirm it. But this one is that you are called in a particular room, in a particular home, in a particular place, and you are paid and you carry it. That's the secrecy that I'm talking about. And no one is going to come for obvious reason and say, I am here, I've received the money. Because many members of parliament are highly indebted. There are people looking for them. The voters are also demanding for this money, and it is. But you can see from the excitement. I had members of parliament who had borrowed some little money from me. They have paid it. And I would say, no, where did you get the money? Because last day,
first of all, this operation is secret. Members of parliament can have their sources of money anywhere else. For somebody to make good to pay his debt, it does not mean he has taken a bribe. But however, you are a member of parliament, you sit there, you understand it better. I'm inclined to believe your story than any other guy on the street. So at least because these are your colleagues. What do you make, George, of these?
Of course, Patrick, the bigger context is that all of us here have been here for a while, and we know that for you even to put Honorable Jonathan on the cross, no one gives corruption at City Square on a public rally. Corruption is always committed in the secrecy. And evidence, even in courts, is usually circumstantial, because in any case, no one gives a receipt after paying a bribe. If you look at the context, all the way from 2005, when there was the first 5 million issue, the person who blew the whistle went to pick his, and that was Honorable Theodore. I think he had gone to pick, and they told him, no, you first go and pronounce your stand on Chisanja publicly before you come back. That's when he addressed the press. No one had blown the whistle. Even possibly if Theodore had picked, maybe he wouldn't have blown the whistle.
So he was so aggressive.
If you talk about the 40 million of this particular parliament, which was, I think, the first disbursement in cash, everyone feigned ignorance, even on the floor of parliament. And it remained, and for me, there's a member of parliament who confided in me then that indeed we picked it. Until we saw Kagabo publicly coming with the money, saying I received it. We all saw it. I think that he was the only one who came closer to the admission. So the context is that many times, because of the purpose, and because even the people, and actually for 40 million, the official position kept on wavering. I remember the communications director saying, no, it's gratuity. Others were saying, no, it's set. So everyone who knows the context and the MPs know that maybe we are not entitled to this money, or it's not an entitlement, it's something to lie in our pockets or to lie in our backs, of course they will not come out to own it up.
So in the interest of time, gentlemen, as we try to conclude our discussion, again with you, George, what's going to be your concluding remark?
Of course, I can only hope that my friends in NRM do the right thing. Because I know that, especially when it comes to the issues of the trial of civilians, we are not saying that there's a group of Ugandans who shouldn't be charged if at all there's any legitimate case against them. We are saying that our courts, as they are, have the capacity to try any offense under the sun. In any case, we also have some problems with these courts here sometimes. So to subject yourself to a court which will be under the whims. Jonathan was talking about, government might change. No, it doesn't even have to change. When in 2016 I was with a group of lawyers trying to prosecute Mr. Kaihura for torture, a person called Chitata then commanded a militia group called Boda Boda 2010, commanded the group to beat us at Makindi. 2 years later, Chitata was before the court martial being charged and was in tears. So you just have to do the right thing, that if there is anyone who you think that has a legitimate case, let us not weaponize, let us even not bring the army into disrepute. When I saw the times Dr. Besige and Obed were appearing in the court martial, and I saw all those altercations between the civilians and the army, for me it was even saddening that why should the UPDF be brought into those kind of altercations? Let the army courts keep on trying people they do best and let them do it competently and independently. All
right, thank you very much, George. By the way, George, you've been fighting, for the people's rights and the human rights lawyer and all that in the trenches with them. Have you reached a point where you think maybe this time around you should ask the mandate to be able to lead?
Absolutely, absolutely. And I will seek the mandate of my party to represent my people in the 12th Parliament, hoping that I will use it as a pedestal to put the fight better in Chira municipality.
So I think Enoch was right. You're more of a politician, huh?
Enoch is the leading politician from the leading.
Okay, it looks like George is eyeing to go Parliament. Enoch, what's going to be your parting shot?
My parting shot, Patrick, is that we must agree on certain fundamentals. And I think the most important fundamental is that everything we do on an individual level, anything we hope for, anything we aspire to, can only be hoped for, can only be aspired for when there is safety. Everything else, human rights, development, economics, wealth creation, everything depends on one simple thing, and that is safety. We must never permit anything that compromises the safety of person and property and the safety and sovereignty of the nation. And to that extent, I propose and I urge all members of Parliament to support the proposals that will come to Parliament, as I have read them to be, that are meant to streamline the operation of the courts martial and to continue to guarantee the safety of persons, safety of property, and the sovereignty of our nation.
Thank you very much. Honorable Jonathan Odu, your concluding remark.
Yeah, we are, as Parliament, we are ready to receive any proposal that comes from the executive, including the amendment to the UPDF Act. And I want to repeat that there are several provisions in that amendment that are good to enhance the welfare of the soldiers, to meet the current structure and etc. I think the ones that deserve our support, we shall. We shall also probably use the opportunity to clarify further on who the court martial should apply to. We can also do that. We can save the courts their interpretation and expressly even put a provision and say this clause, no civilian. In the Act itself, we can solve that once and for all so that we don't disturb courts. So we should not be looking at it that as if MPs are robots that are programmed to think in a certain way. We shall receive and we shall use the same judgment to clarify as legislators now, to make it very clear and put a clause that this UPDF Act is not applicable to civilians under any circumstance. Thank you
very much, Honorable Jonathan Odur, Member of Parliament for Erute South. Thank you so much, Mr. George Musisi, human rights lawyer. And thank you, Mr. Enoch Barata, Director of Legal Affairs at the NRM Party. Gentlemen, I thank you so much for the time you've given for the submission. And you, the viewer, I want to thank you for the privilege of your company. Good night and God bless Uganda.